So, you filed a lawsuit, months go by, and suddenly, boom, you're rehired with a shiny new contract. And you sign that new contract, but it now includes an arbitration clause. Now the big question, can they yank you out of court and toss you into arbitration? That's the legal cliffhanger at the center of today's episode of 99 Rights Online. And the twisty tale of Russell v. Citigroup, a 2012 Sixth Circuit case that proves timing isn't just everything, it's the whole contract. Keith Russell worked at Citicorp's call center in Florence, Kentucky from 2004 to 2009. As a condition of employment, he signed an arbitration agreement, but it only covered individual claims, not class actions. In January 2012, Russell filed a class action lawsuit against Citigroup, claiming the company failed to pay employees for time spent logging into and out of their computers each day. Because the original arbitration agreement didn't cover class claims, Citigroup didn't seek arbitration. Then came a twist. In late 2012, while the lawsuit was still active, Russell reapplied to work at the same call center. He was rehired in January 2013, and this time, he signed a new arbitration agreement that covered both individual and class claims. Russell didn't consult his lawyers before signing, and Citigroup's litigation team didn't know he'd been rehired until a month later. Once they found out, they moved to compel arbitration, arguing the new contract applied to the pending lawsuit. The court basically said, "Nice try, but your contract isn't a time machine." If you want to drag old lawsuits into arbitration, you've got to spell it out. No vague vibes allowed. Disputes that arise means new drama only, not the skeletons already dancing in the courtroom. The court emphasized that contract language matters. The phrase, "disputes that arise," signals future claims, not those already in progress. Without clear, retroactive language, courts won't force arbitration on existing lawsuits. For law students, Russell v. Citigroup is a lesson in temporal scope, how timing and language shape contract enforcement. For everyday workers, it's a reminder. Signing a new agreement can affect your rights, but only in the future, unless the contract says otherwise. And for employers, it's a warning. If you want arbitration to apply to past disputes, you must say so, clearly and explicitly. Russell v. Citigroup teaches us that contracts don't reach backward unless they're written to do so. For more case briefs and creative law study tools, subscribe to 99 Rights Online. Let's make the law make sense together.